Hello, I'm Faye Rozovsky from the Rozovsky Group. I'd like to share with you today some information on a recent decision involving informed consent. Late in November, the Texas Supreme Court issued an important decision involving consent to treatment. The case involved a patient who had experienced a vertebral dissection immediately after his third chiropractic manipulation. Prior to treatment, the chiropractor had taken a history and completed an X-ray. However, he did not disclose the inherent risks associated with the manipulation used in this case. Texas has had for many years a stylized approach to consent. An administrative body determines whether a medical or surgical procedure includes risks that should be disclosed or not disclosed. A consent framework exists to, in essence, plug in the risks that merit disclosure. Now, in the current case, the court made clear that when a statute is silent on a particular type of treatment, the common law is applicable. Here, in other words, the Texas Medical Liability Act is not controlling of all consent issues. The court delved into what constitutes inherent risks for purposes of disclosure to a patient in the consent communication process. And importantly, the court took note of some limitations on the expanse of information that should be shared with the patient. The court said, and I quote, "A reasonable healthcare provider must disclose the risks that would influence a reasonable patient in deciding whether to undergo treatment, but not those that would be unduly disturbing to an unreasonable patient," unquote. Contemporary healthcare is coming to grips with the idea of shared decision-making. It presumes that care providers and patients alike will operate on a level playing field. But when the highest court of a state suggests that quote-unquote unduly disturbing inherent risk information might be withheld from an unreasonable patient, how can one engage in shared decision-making, let alone informed consent? The most recent issue of Dialogues in Healthcare from the Rozovsky Group examines this case in depth and offers some practical communication strategies to make available in an understandable way inherent risk information to patients. Please visit our website and look at this issue of Dialogues in Healthcare. And if you have any risk management or communication issues involving consent, please contact us. Thank you.